There's paperwork down there. He's doing a conditional plea.
All right, I've been handed a document indicating Mr. McClanahan is going to enter a plea under 4035-313, which is what we call a judicial diversion or post-trial diversion, to aggravated assault, and was to be placed on probation for 3 years to have no contact with the alleged victim. He would be ordered to pay a $4,000 restitution, and his GPS monitor would be coming off if deferred. Is that right? What about the monitor?
It will come off as a condition of this.
All right. Mr. McClanahan, raise your right hand. Let's place you under oath.
Yes.
State your full name for the record.
Patrick McClanahan.
Mr. McClanahan, you are here today on actually an indictment charging you with both aggravated assault, domestic assault, false imprisonment, and reckless endangerment. It's been indicated that because you have no prior criminal record, that the state has agreed to allow you to enter a conditional plea, which is basically where you would enter this plea and be placed on probation for a period of 3 years. If you comply with all of the conditions of your probation, then you would have the right at the end of that time to apply to have your record expunged. But if you violate your probation or you get arrested on some new charge, then this would become a permanent conviction on your record, and you would be required to serve a 3-year sentence or be brought back to be sentenced within the range to even more than 3 years. Do you understand that?
Yes.
Do you understand what you're charged with? And have you and Mr. Lockhart had a chance to talk over what the charges are, what your possible defenses might be, and your range of punishment you're facing?
Yes.
Well, it's indicated you want to enter this plea of no contest. Do you understand you have a right to plead not guilty and have a speedy and public trial by jury on all these charges?
Yes.
You understand that if you went to trial, you would have the right to have a lawyer and to have one appointed if you cannot afford your own?
Yes.
Do you understand that if you went to trial, you would be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes.
You understand that if you went to trial, you and Mr. Lockhart could confront and cross-examine all witnesses the state might call to testify, and you could bring in your own witnesses by using a subpoena?
Yes.
You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes.
You understand that if you enter this plea, you're waiving your right to that appeal and to the trial, and all I'm going to do is approve what your lawyers worked out?
Yes.
You understand that what I've explained to you about being placed on probation and the requirements that you have to meet for that probation will determine whether or not you can have this record expunged,
Yes.
whether or not you're successful on probation. Do you understand everything I've explained to you?
Yes.
And you understand that if you violate your probation, not only would you have to serve the sentence imposed at a separate hearing, but you would also have a permanent conviction on your record that would make more severe the punishment you received if you're ever again convicted of a crime.
Yes.
Is your decision to enter this plea according to this agreement?
Yes.
Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I can't accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty of these charges?
Yes.
Now I want you to listen as the state tells me what their evidence would be if you went to trial.
Yep.
General?
Your Honor, the case where you go to trial, the state would show that on February 14th, 2025, Valentine's Day this year, officers responded to the home of Janelle Williams located at Mosley Ferry Road. Ms. Janelle Williams had been involved in an altercation with the defendant. During the argument, the defendant broke multiple items that belonged to Ms. Williams, such as a phone, TV, and 2 slashed off-road Jeep tires. The defendant pulled Ms. Williams from the house by her arm. He then did display a gun while holding her on the ground and shot off a round, scaring the victim and placing her in fear.
I'm not asking that you agree with those facts, but do you understand that's the state's evidence they would use at trial?
Yes.
You still wish to enter a plea no contest according to this agreement?
Yes.
Are you satisfied with your attorney's services?
Yes.
Feel like Mr. Lockhart's done a good job of representing you competently?
Yes.
Mr. Lockhart, do you know of any reason you should not enter this plea?
No, Your Honor, and I've also explained to him that, General Sylvia said if he does violate, he needs to understand it'll be 3 years at 100%.
You understand that?
Yes.
And that, as Mr. Lockhart says, that 3 years, but as I explained to you, under 4035-313, if you violate the terms of that probation, then you can be brought back and sentenced to more than the 3 years if you violate it. We're giving you 3 years probation. If you stay out of trouble and do what you're supposed to do and have no contact, then that will be the length of your probation.
Yes.
All right. I've signed a no contact order that you're to have no contact with Janelle Williams, period. All right. Thank you. He needs to see the probation department.
And, Your Honor, any idea when he could get something, that would allow him to get this monitor off his ankle?
Probation department can explain that to him, but I would assume it could be done today, so.